Well, good morning, everyone. Good morning, and welcome to what promises to be a very informative hour as we invite you, the members of CAM and Automate Canada, as well as future members of our associations, to a webinar focused on returning to the workplace, what employers need to know. So if I could invite Michael and Brian to turn their cameras on and their microphones. So just a quick introduction for today before I hand things over to Michael and Brian. Based on the feedback that we, Automate Canada and CAM, have had from our COVID-19 impact survey that we launched 6 months ago, we know that the information we gain today will be valuable and it will have a positive impact on our businesses. Thank you to everyone for choosing to spend your time with us today. We've got an outstanding pair of experts with us from the employment law firm Sherrard. Michael Sherrard is someone, and I told him this, I took his very extensive bio and compressed it down to just a couple of sentences. He's one of Canada's leading employment labor lawyers and a recipient of several awards. He's a member of a large number of US and Canadian bar associations, legal associations, and industry councils, including the Canadian manufacturers and exporters. Brian Wasyliw is an experienced and accomplished employment and labor lawyer as well, with a background in commercial litigation. He's a member of several law societies and bar associations, as well as the Retail Council of Canada, the International Municipal Lawyers Association, and many of us may be familiar with this one, the Eve Laundry Foundation. If you turn on your chat function, you'll see some information regarding today's webinar. Please submit your questions via the chat and direct it to panelists. Those questions will only be seen by our panelists and our moderators, so it will help protect your confidentiality, as well as help us in managing the questions as they come in. Mike Bilton, who's the chair of the Canadian Association of Mold Makers, CAM, and I will be moderating today, as well as the Q&A session that we'll have. There he is. Good morning, Mike. The Q&A session that we will have just prior to 12:30. Before we start today, I'd like to acknowledge that while we are in virtual space with a webinar, on behalf of those of us who are down in Windsor, Essex, we'd like to acknowledge the presence of the Three Fires Confederacy peoples in our region. Those are the Ojibwe, the Ottawa, the Potawatomi, and the Huron-Wendat, as well as the Caldwell First Nations. So with that, I'd like to turn things over to Michael and Brian. Take it away, guys.
Thank you.
Thank you, Shelley. Thank you very much. And thank you to everyone. We appreciate the time this morning. And my colleague Mike and I are very hopeful that we can help you get ready and navigate the road ahead. We have some slides that we'll run through today, and then there will be time at the end for some questions. The idea would be to catch us up very quickly on timelines and where we're at. Specifically, there's a particular deadline coming up that a lot of employers are mindful of that I'll put on your radar, and it's tied to the next item on the list, one of the regulations that came out in Ontario to help employers deal with layoff situations. We'll talk about return to work guidelines, which is largely a health and safety issue. What to do if your employees are refusing to come to work now or in the future. What if they're refusing to come to work and then in a more, instead of a safety work refusal perspective, but an absenteeism, either they cannot or won't or don't want to come to work because of their personal circumstances. And that itself is also tied to something that we expect is going to be a hot issue in terms of return to school and what's going on with childcare issues and how that might play out. If you do have an employee who is COVID or suspected COVID, what do you do? And lastly, Mike has some comments and thoughts on contact tracing and where that situation is sitting right now and what might be useful to employers or just individuals at large. So in terms of where we've been and where we're at now, seems like a long time ago. In some respects it was. Certainly a lot has changed, and there's been a lot of uncertainty all through the period since March, when the pandemic really hit us here in Ontario and Canada. So there was a state of emergency declared back at that time, and government relatively quickly reacted with some legislation. There's a reference there to Bill 186, and I'll be referring to that specifically because of emergency leaves that were created and still exist regarding an employee's ability to have an unpaid leave of absence from work for COVID-related reasons. Either they're in quarantine, they're being investigated, they have a health issue, or they're in a high-risk group. And that's an entitlement factor. So we'll talk about that specifically. The regulation that is passed regarding non-essential businesses and essential businesses, it was modified and changed as we went along. We know now that we've moved through the different stages into stage 3, most of us, and it's going to go forward there. Potentially, if we hit second waves, we could see a similar sort of staging process take effect, where we're looking at different businesses or industries and deciding what's essential and what isn't. There's a reference there to Ontario Regulation 228 again, and so that's, of course, the technical name for it, but this is the one that dealt with the layoff issue, and I'm going to get into detail on that in a moment. Where we're at right now, and tied to Regulation 228 and dealing with leaves and layoffs, we have Bill 195, which was the start of the reopening of Ontario up until July 24th, when we've actually declared the emergency to be over. And so there's timelines that run from that. So specifically, one of the issues that we're dealing with, or that employers are dealing with in terms of what to watch, and a deadline that's coming up, is dealing with this issue of layoffs and termination. So we know that if an employee, under the Employment Standards Act, if an employee is receiving less than 50% of their wages, they're on a layoff. Okay, and you could put them on a layoff, and a lot of employers did that in the beginning stages in March, and wanted to put their employees on a temporary layoff. Okay, and what that meant was that an employer can put their employee on a layoff under the Employment Standards Act for a period of up to 13 weeks in a 20-week period, a rolling period, or you can access a longer period of layoff, 35 weeks in a year, if you're providing some other benefit, keeping benefits going, or you have a supplemental unemployment benefit program. The ESA enumerates some conditions under which an employer can access a longer period of grace for a temporary layoff. And what I say when I say a period of grace, because as soon as you've hit that mark, that threshold where the 35 weeks is reached or the 13 weeks are reached, the layoff turns into a termination under the Employment Standards Act. So that was a problem because many employers would be running up to that period in the middle of this summer or the end of the summer, had not the government introduced Regulation 228. And what that regulation did was it said for non-union employees, the layoff is not actually a layoff. It's going to be considered a leave of absence. So the effect of that is the clock is stopping on those 13 weeks and the 35 weeks. And what that means is for the non-union employees, we're not going to count that time that they've been off on a layoff as a layoff. It's just going to be considered a leave up until that order is ended. And that's what has recently happened with respect to the end of the emergency. Okay, and so the new deadline that everybody is mindful of is September 4th. Okay, so as of September 4th, and I'm going to jump a slide here, the leave is no longer going to be in place. So you have to consider for your non-union employees to bring them back to work. Okay? Or otherwise, if you're going to keep them off work, and more accurately, if you're going to keep them making less than 50% of their wages, then they are going to be on a layoff again. And that's, a capital L layoff for the purposes of the Employment Standards Act. And what that means is that there's a couple of things. So number one, you're going to start the clock on that 13-week and 35-week. Potentially a more interesting other issue of risk is you're going to be introducing a matter of constructive dismissal. Okay. So for employees that, if we want to rewind the clock back to March, there was always a risk with respect to a non-union employee being told to stay home or we don't have any work for you. Okay. The risk is there because, notwithstanding the fact that the Employment Standards Act provides for the rules around a temporary layoff, there's numerous cases in Ontario that have said that doesn't give an employer the right from a common law perspective. In other words, with their relationship with a non-union employee, they don't have a right to lay someone off. If they are going to lay someone off, if they have the right to do that because their contract says they can, or because they have a very long practice of doing so and the employees have accepted it, then the rules for doing that is what the ESA says. Okay? So there was that risk. We had a lot of discussion with a lot of clients about how do they deal with that, because if an employee is successful in a constructive dismissal claim, it means they're walking away from their job and you're going to have to pay them common law notice, which can be very substantial. We felt that a lot of employees still might not want to do that because you have to trade your job for a lawsuit, and we didn't see a lot of claims. Then the government came forward with OREG 228, which basically says it's not a constructive dismissal and it's not a layoff. And more accurately, it's not a constructive dismissal unless you've already objected before this legislative change. The impact of that was that we weren't seeing a lot of claims. We've started to see more where employees are claiming common law entitlement to constructive dismissal, recognizing that the Employment Standards Act is a separate issue. So what that means in practice is we're going to head into a period as of September 4th where you're going to have to decide, can you bring your employees back, your non-union employees? And if you can't, you're going to be in a situation of risking constructive dismissal claims. Hard to predict exactly what the courts will do with that because we haven't seen any that have been argued all the way through. I think there's a strong argument that situations have changed, businesses picking back up, and the employee might get some sympathy in terms of no ability to be laid off. I could see employers arguing in the converse, well, we laid you off back in March or April and you didn't claim constructive dismissal, so you've accepted that this might happen. It'll be an interesting argument, and it's unfortunately a little bit difficult to predict. If you want to avoid that risk, you have to consider as much as possible how to bring the employees back. Very quickly on that, before moving on, I'll talk quickly about the union context, because that regulation did not cover union employees. And so what that means is the clock has been running for union employees under the Employment Standards Act for the 13 and 35 weeks. Of course, in a union context, you have a separate issue with your collective agreement. You have to look at both and you have to work them together. The way that they work together is if under the Employment Standards Act, you hit, for example, let's use that 35-week period. You hit that 35-week period, it's a deemed termination. For a union employee, what it effectively means is they get an election. So if they don't want to be terminated and they want to instead maintain their recall rights, because many of your collective agreements would say an employee holds recall rights for up to a year or even longer, they can choose to maintain their recall rights and not be terminated. So wanting to still avoid that problem, some employers were actually recalling employees, but not having them work. They were paying them perhaps at 75%, so it wasn't down to a layoff, and getting the wage subsidy. So we know that the wage subsidy has been extended and it's been changed. So there may be opportunities there that you'll want to consider if you feel like you need to bring employees back because you don't want to have them lay off, whether they're union or non-union. Can you access the wage subsidy so that you can survive without while pushing back this timeline of terminating your employees? Because that can trigger other liabilities that you didn't really intend. So September 4th is the magic date. And if you have concerns about ability to bring back employees or triggering some of those timelines, then you would want to look in more detail at some of your options for bringing them back or not, and what the risks flow from there. As we all move back into work right now, Mike is going to discuss returning to work and some of the guidelines you want to set up for your workplace.
Yeah, just as I touch on that, thanks, Brian. The one thing Brian mentioned too is really a lot of proactive planning. If you're still in a situation where you have a number of employees that are furloughed or laid off, a number of Brian's clients, I've listened to the conversations around planning how that's going to look in September and October, because you really do want to plan how those trigger points happen and keep control of them. What we're hoping to do next in the return to work guidelines is to think not only in reviewing what you've already done, because many of you are returned to work, you've ramped up, some have been more fortunate than others, but we're also worried about a second wave. So I want to keep both of those concepts in mind, reviewing what we've done to date, but reviewing what we also need to remember of what we've already learned in case we do get back to more restrictions in Ontario specifically. We know everybody on this phone call is used to reading and understands traditionally what the obligations of the Ontario Occupational Health and Safety Act requires of us. The phraseology that people use really are the employer must take all reasonable precautions or all reasonable steps in the context. The context is the magic word, and we have some case law that can give us some direction. The most recent one in Ontario, if you go back in the case law, back in the SARS days, we had judges make comments about what employers' obligations were in terms of the kind of precautions they ought to take. The other side of this, and you heard in the introduction from Shelley today that Brian's got some commercial law background as well. We also had what I'll call commercial or personal injury lawyers raise claims under tort law. And what I mean by that is really a concept called the duty of care. And so employers are well advised to think of what are my obligations under the Health and Safety Act, and how does duty of care play in or not play in? And duty of care really is simply saying, if you're an employer and there's a risk, what have you done to mitigate that risk? So it really does overlap a lot with the Health and Safety Act. The key on this slide, though, is that middle bullet. And while it was put in place with respect to the Emergency Act, I think it still provides us with great guidance. And the Ontario government, I think, has done a great job with providing us with sector-based guidelines that you can download and look at. And I know a number of you have already looked at them. The key is they're saying the standard is something that is set really by public health. And we know this is ever evolving. And so it's very key that we pay attention to what public health is telling us to do. And you know, we've had different notifications from public health as it relates, for example, what's the utility of the mask? Is it 2 meters? And if we're inside 2 meters, is the mask really going to help us or not? Seems to be today that the guidance out of public health is in fact that the mask actually is quite important if you can't social distance. So that's just one example. But so the standard you're looking at is, what are the risks I see in front of me in this context? And what do I need to do to mitigate those risks? What's reasonable in those circumstances? And I think it really starts with having somebody in your organization who is either, in our words at Sherrard, we'd call the champion of adhering to these standards. The other side of it, so champion being the carrot side, the other side is the auditor or the checker. And so I think in your organizations, you really need, and I think it's prudent to have somebody who's going to be the champion and who will model behavior, and frankly will also hold people accountable. Because it's one thing to put these standards in place, it's another thing to make sure we all adhere to them. So with that, if we look at the next slide, let's start with some of the basics that I know a number of you have been through already. These hygiene protocols are pretty critical. And I think what we've said and we've learned from a number of our clients, it's literally walk from your front door to your back door. Walk through your offices, walk through your plant, your facility, your shipping departments, your tooling sheds, if you have a stock department, and really look at what the employee experience is and what might they be interacting with as they come back to work, or God forbid, we do get into this second wave, will we shrink things? And so some of these things have worked really well. I think we commend employers to put together a policy that actually is directly speaking to the circumstances arising because of COVID. We think it's really important that there are lots of posting, and those are free downloadable posts. They're very accessible, I think, on the internet these days. We forget, right? The basic is public health has told us hand washing is one of the #1 things that will help us here. And so do we have enough areas where employees can actually hand wash? Even in an office space, we have a number of stations around the workplace that have hand sanitizer and the kinds of disinfectant that you would need subject to the context you're in. And I think a lot of you have done that. The tip here is if we've got a second wave coming, and let's say that's October, and it mixes in with the flu, have you already got an inventory of the kind of materials that we know we all scrambled to get, not that long ago, 3 or 4 months ago? So are we doing the planning now, again, just in case this second wave hits? And so I'd commend everybody to take a look at your inventories and keep an eye on public health. But I think I'd be stocking up on inventories, and I'd be checking the usage so far so I get a sense as to what I might need if we have to work through this in the fall. If we move from there, physical distancing works and doesn't work. It really is contextually driven, and I know a number of you have already looked at it. We've had everything from adding a second shift so that we can spread people out. There's actually some board case law I'll talk about a bit in a manufacturing facility where they were looking at whether or not the people on the line in that facility could socially distance, and if they couldn't socially distance, was it a shield or was it a mask? What was the appropriate thing to do to comply with health and safety in that context? So things to think about. If you can't socially distance, can you use plexiglass barriers or not? In terms of floor markings, they work some places, not always, but look, we're used to having lines on our plant floors in terms of where material handlers can travel, whether that be on a forklift or in a push trolley. So it's not that foreign to us, but pretty critical. Take a look at physical distancing next. We move from there, we move into the next slide that's all about PPE and personal protective equipment. Every municipality seems to have some variation, at least on timing, when they put their rules in place. Most of the municipalities around the province have been picking up the mask or the face coverings. And so we commend you to look in your particular municipality. And if we've got a second wave, are we going to see, for example, stage 3, back to stage 2, back to stage 1? And we'll want to pay attention to those kind of things. If we move to the next slide, I think our experience has been many of you are already back to work. So let's look at this as if we're actually shrinking from 3 to 2 to 1 again. And what are we going to do before employees come back to work? We learned a lot over the course of these last 4 months. And what we did learn for sure was if we could communicate effectively our expectations of our people before they come back to work, we actually reduced a lot of the stress and frankly, a lot of the worrying work refusals, because we illustrated to them the kind of steps we were taking and also what we expected of them when they came back into work. And so I think you warehouse that. You have your policies updated in case you need them again. And like everything, you train an employee once, you probably have to communicate again, at least audit to see whether you're getting compliance. But again, we've learned a lot. We need to use that as opposed to try to reinvent the wheel. We move next. I want to just talk briefly about this next case. I apologize. One of the things I should have covered, Brian, if we just go back for a moment, one slide. The one thing I want to mention here before I leave this quickly is champions, or for example, maybe the people that are on your joint health and safety committee, those people can be very good to model behavior. We can't have executives or leaders walking out in a facility when they're asking everybody else to mask, not to mask ourselves. Or when we're asking everybody else to wear PPE, not to wear PPE. So the last comment on this slide was, let's make sure we're modeling behavior. And that means if I'm an executive and one of my executives sees the other executive not modeling behavior, we need to hold each other accountable and help each other, because we really need to lead in this area. The next one is a case that the Labor Board has issued most recently. What happened was they went into a facility. This was a food manufacturing facility, and they saw that people on the line could not socially distance. But when they were observing the workers, and this was a Ministry of Labor inspector, they saw workers not socially distanced nor wearing masks. And so they issued an order to the company to say, all your people must wear masks. And the company felt that the mask wasn't an appropriate order. And they went to the Ontario Labor Relations Board and they appealed the order. So you can always do that. And Brian's going to talk a little bit about work refusals shortly. In this case, the ministry said, back in the SARS days, a couple of Ontario judges came up with what they called the precautionary principle. And really what they said was, we're not certain with respect to how this influenza or this virus is actually being transferred. Is it droplets? Is it airborne? Can it stay on a stainless steel counter for a period of time? Because we're not certain, we need to take precautionary steps. They may not be perfect, but we're going to take precautionary steps. And that influenced taking every precaution reasonable in the circumstances. And what the Labor Board went through on this case was they said, we believe a mask so far is at least fitting within that precautionary principle. And what it does is it at least prevents the droplets from leaving that individual. And so far on science thus far, we believe the mask is better than not. And one of the debates was, well, with people with a mask, they'll touch the mask. And won't that spread a risk too? And the board actually said, we can train people not to touch the mask, so we can alleviate that risk. But in today's science, we believe wearing a mask when you can't socially distance is necessary. And it made a bunch of sense, and they denied the appeal, and they upheld the inspector's order requiring people to mask. The analogy is, and I have kids at home who are going out a bit, and when you listen to the conversation around them, and I think our employees do this too, oh, well, now we can have 50 people. Well, remember, you can have your 50 people, but you still must socially distance, and or if you can't, you must mask. And some people forget that and they run with just that first title. So I think it's very important that we continue to use the mask where we can't socially distance. And we think of that in all the guidelines that you're putting in your workplace to begin with. This next slide just has a final comment with respect to, and it's just a quote. And I think this is what we should think about with respect to all the kind of precautions we're taking and asking of people. We're guided by that precautionary principle. If there's a risk, what's the reasonable thing to do to mitigate the risk? And it's a disciplinable event from our perspective if we've trained and told people they must wear the mask and they don't wear it. I've actually seen, unfortunately, in a certain context, a termination where they asked an employee to wear the mask and the employee simply turned the mask around and the mask was on the back of the head with the strings out front, frankly mocking and making fun of the employer's effort to try to get them to risk mitigate. And in that situation, they didn't terminate immediately, but they coached, counseled, retrained, cajoled, all of those kind of things before they moved to termination. But we do think in the appropriate context, employers have to think about that. On that next slide, the other things these ones are relatively obvious. If you can have multiple entry points, it's good, on the assumption you can have a control mechanism on the multiple entry points. The one I want to spend just a minute on is the second bullet on screening protocols. A lot of us gave advice and we debated the utility of taking an employee's temperature. We know today that taking an employee's temperature is not enough. It must be part of an overall screening protocol. It starts with a health screening questionnaire. And without going through the entire list, here are the 4 things I would think about if I was putting this together again, or I was reevaluating how I'm doing in terms of screening people. Because remember, we're trying to screen people who might otherwise expose the rest of your workforce. So there are going to be times when we send somebody home, we don't let them come to work. They don't have COVID. They may not really have enough COVID symptoms, but out of a sense of security, we're going to try to keep the rest of the workforce safer and have somebody go home. So I would say here are the 4 areas. You're going to ask them about symptoms, and the symptoms you can list out, flu-like symptoms as an example, but we know public health has helped us. You're going to ask them about symptoms. You're going to ask them about whether they've traveled in the past short period of time. You're going to ask them whether they've been exposed to anybody with COVID. And then finally, you may, and we still think it's a good idea to take temperature. Remember, we want to do that in the least intrusive means possible. And many companies have picked up those temperature checks where you can put them up to the person's forehead, and you're not doing anything intrusive. But remember, it's all 4, not one or the other. I think with that, I'll turn it back over to Brian, who will navigate now. What do we do when we have these work refusals? Because they're still coming, and with a second wave, they may escalate.
Yeah, thank you, Mike. And I think that's right. They may escalate. I mean, on the work refusal point, we as an employer, you've taken your precautions in the workplace that Mike just ran through. But your employee is still refusing to work. And this is all talking about on the basis that they feel it's unsafe. So how you handle that in the COVID circumstances is actually mechanically not different than how you handle an ordinary health and safety work refusal. And the first step is to educate the employee on the precautions that you are taking. The purpose of that is just so we're all clear, here's the process, here are the precautions. And if the employee still refuses to report to work, then you do need to do an investigation. And that means involving your joint health and safety committee and coming to a conclusion, okay, have we taken all the reasonably necessary precautions to protect health and safety of our workers or anyone in the workplace? And if you decide that you have done so you might say, okay, well, we could introduce a screen, or we could put out hand sanitization stations, and that would be a better way to make sure that our employees have the opportunity to be compliant with sanitation and hand washing. If you've decided that you've taken all the reasonable precautions and the employee is still refusing to report to work because they think it's unsafe, then you involve the ministry. And then the ministry will come and do their assessment, and they will either decide, okay, you need to change some things, and then the employee is required to report to work, or they'll say, no, employee, you need to report to work because we don't agree that it's unsafe. We believe that the precautions have been taken. And what we saw was there certainly were a lot of work refusals when the pandemic started. And in fact, to the point where some of these ministry investigations were actually being done quickly by the phone. The long and the short of it is that through that period, and I don't think the numbers have changed dramatically, and Mike could correct me if he's heard otherwise, but I think vast majority even understates it, that we found that a lot of, and it was mostly essential businesses that were still working at that time, had taken a lot of precautions and were following all the public health advice. And in the high 90% of cases of these work refusals, the ministry was deciding the employee was still required to report to work, that the work refusal was not justified. So we will see, but it does seem that because employers are taking these precautions very seriously, the outcome is that a lot of these work refusals are not being upheld and the employees are being told to work. So there's other issues of employees not wanting to come to work that are not strictly related to the precautions in the workplace, but they might be related to other issues, like, for example, that the employee is of an advanced age, or they have an overlapping medical condition that puts them at risk. So the protections that I mentioned at the outset are still in place with respect to an entitlement to have an unpaid leave of absence. And there's certain criteria that are set out, but the main ones are if you're at a risk group, so over the age of 70, or you have other comorbid medical conditions that are enumerated out by public health, or you have to care for a family member that is in one of those categories or is required to be at home or you're returning from travel. So there's specific enumerated situations where you're entitled to an unpaid leave of absence. And foreshadow a little bit, but one of them is also you're required to care for a school-age child who is at home, can't go to school. So if one of those COVID-related reasons, those identified reasons is why they're not coming to work, then you're going to have to let them have an unpaid leave of absence. An important note with respect to the fact that you're not permitted to press them for medical substantiation. So you could, in some circumstances, I mean, if you had reason to doubt them, you could ask for confirmation that the daycare is not accepting any children or things like that. But you couldn't, for example, say, well, I want to see a note from your doctor that says you have lupus. And your employees may share with you the details, but you can't require them to substantiate that sort of a personal medical issue. One of the other one of the big issues that's coming up is this issue of childcare or elder care. So again, it could be that the employee is is entitled to a leave because they are required to take care of that person, and so the Employment Standards Act will entitle them to an unpaid leave. And just a quick note that I'm sure everyone knows that you can't sort of be upset that employees accessing a leave that they have an entitlement to. So just a general caution about not reprising or visiting any consequences on the employees for accessing something that they are entitled to, as much as it might be frustrating for your operations. Now, let's deal with the specific situation of someone who says, okay, well, I need to stay home because of my child or an elderly family member that I need to take care of. There's two separate ways to look at that. Are they entitled to that leave, an unpaid leave? In which case you look to the Employment Standards Act, and the tricks there are, so yes, that first person needs to be at home. Either the elderly person is at home or the child is at home. And now this employee requesting the time off is a required caregiver for that person, in which case they would be entitled to an unpaid leave. There's a different analysis that runs in parallel, which is the accommodation analysis. And what I'm really speaking about is family status. And so that can look like different things. It's essentially an employee saying, because of my family obligations, I need an accommodation. That accommodation could be, I need time off and it wouldn't be paid. Or that accommodation could be, I need you to let me work from home and pay me. So if we get through the front door of engaging, yes, that is a family status issue that we are required to accommodate to the point of undue hardship, you need to analyze your undue hardship analysis. It's not going to be a situation where you're going to have to require, if someone's not working, you're not going to have to pay them, but you are going to have to consider, okay, they could work from home and do work and get compensation for the work that they're doing. Where is this going to go with respect to particularly the big issue of returning to school? We know that the Ontario government has announced that they're reopening schools. You certainly are not going to hear, at least to date now, public health or the government say that it's unsafe for children to go to school. So that's an important, I think, foundation as I get into this next topic. The default is that the government and the public health is saying it is safe for children to be in school under the circumstances that we have set up. Okay, so, and why I say that is because, and you see the circumstances listed on the slide, we're all pretty familiar with them. For the younger kids, issues around masks and concentrated classes, they're not allowed to hang out with children from other classes during recess, at least that's what my children have been told. Whereas you get to the high school age children, I say, or teenagers, they might be going on a rotation, an on-off, at home, at school kind of basis. So it's going to depend on what age group we're talking about. But bear in mind that the fundamental piece there is that this is a decision. The government's given the parents the option to have their children learn remotely, but the basis for that is not them saying it's unsafe to send your kids to school. Okay? So why is that important? It's important because Therefore, you have an employee who's saying, well, I need to be home to take care of my child because my child's not going to school. Well, that's a different circumstance than the one that we had earlier this summer, well, spring, when the legislation came out that said if you have to be at home to care for a child who's not in school, you get an unpaid leave. It's not required that the child be at home. It's now moving to the category of being a decision. So if you're going to look at an employee who wants to be at home and wants, because their child's going to be at home, you're going to be looking at the accommodation analysis, okay, a family status issue. And we don't know exactly yet, but our job is to analyze it and predict it. And we think that there's going to be a lot of difficulty. There's an uphill battle for a parent to establish on a family status basis that they need to be at home with their child. Why? Because it has to be a requirement, okay? It can't just be a choice that you prefer them to be at home. So the situation will get more complicated if you have medical issues overlapping, or, let's use the example, and I think there was a question sent in advance of the seminar of someone who wants to homeschool their child, right? Or they want to be at home because they have to homeschool their child. It's not different than before, where someone chooses to have their child at home for homeschooling. That is not a situation that's likely to give rise to an entitlement to accommodation or get through the front door on a family status issue, of it being a condition that is sort of put on them or required on them because of these care needs. There's that element of a decision or an election on the part of the parent, and that's why a couple of minutes ago I put such heavy emphasis on the fact that in no part of this equation is some official saying it's unsafe to send your kids to school, right? So it gets complicated if your kid has a medical condition. We're talking about a different situation then. But in the general course, I think what I'd say on that as well, with respect to that, it goes as well with work refusals, just as an important thing to keep in mind. I'm a lawyer. I'm giving you the lawyer view, the arguments, the requirements. There's a different angle of always considering, of course, what do you want to do, right? So how many of your employees are not wanting to come to work? Is that causing operational problems? So you might decide you don't want to fight your employee. Could be the decision for a variety of reasons. We did have some employers, for example, there were employees that were refusing work. They didn't want to force them if they felt unsafe. They felt it wouldn't be a good employee to have in the workplace at that time. So they said very clearly, we don't agree with you that it's unsafe, but if you want unpaid time off, we'll give it to you. So you have choices, but in terms of what we've laid out in terms of obligations and requirements, that's the landscape. So we will see what happens with the return to school. We do expect that there might be some issues about parents not wanting to come to work. The schools are asking parents to make decisions and then setting up windows when the parents can change their minds about children attending or being at home. But we think that there's always going to be particular circumstances on individual bases that might change the general approach, but we think it's going to be difficult for parents to choose to have their child at home and say, I can't come to work because I'm choosing to have my child at home. And childcare updates for nurseries is the same thing. There's a lot of rules and regulations regarding making sure that return is safe. And so that's the fundamental buttress of it's considered safe to send your kids to school or to daycare. If you do have an employee that has a probable or confirmed case of COVID, again, the self-isolation for 14 days. During that time, they're going to be on a medical leave of absence. It's going to be unpaid unless you choose otherwise. There would be potentially access to like short-term disability or sick days in that period. And I think one of the critical pieces there is that you're not going to have that employee return to work until there's a clearance. Have they been tested? Have they gone through that? Or do you have a medical certificate saying that it's safe for them to come back to the workplace? What do you do in terms of your other employees, or the fact that you've now had an employee in the workplace that is positive or suspected positive? So you would want to do an investigation of contact. Who's the employee been in contact with in the past 3 days before they were symptomatic? And this is all based on the public health analysis of transmission, what best information they believe. So you want to privately speak with any coworker who is in contact. You don't have to identify the person. You just say, we have looked at it. We know that you're on a list of people who may have been in contact with someone who may or may not be positive with COVID. And so that employee in the contact circle is also going to have to isolate. If the diagnoses are confirmed, then your joint health and safety committee needs to get involved. You might have obligations as well to inform your trade union. With respect to authorities, what is the obligation? And the short answer is there has to be a certain trigger for it. So if one of your employees says and turns out to be COVID positive, you're not required to report that to the Ministry of Labor. You are required to report to the Ministry of Labor if the employee asserts and says, I believe I got COVID from the workplace. In that circumstance, you have to report. Or, which is really the same thing, if the employee submits a WSIB claim saying that they've contracted COVID in the workplace. In that respect, for those of you who may or may are not aware, COVID cases are being treated as a group across all the schedules. So an application for workplace injury benefits because of contracting COVID in the workplace doesn't get visited on any one employer's premium. It's spread out across the schedule. Lastly, I think Mike wants to give an update regarding contact tracing, and then we'll open up for questions.
Great. Thank you, Brian. So I'll be half-decently brief on this. The reason we put contact tracing on this is because we know over the course of the last 2 or 3 weeks, the federal government and the Ontario government have come out with a COVID alert app, and they're encouraging people to download that app onto their telephone devices, I guess is how I would put it. Key for everybody on this phone call is to understand that the federal government and the Ontario government sought opinions from the Federal Privacy Commissioner and Ontario's Privacy Commissioner. On the basis of the app being voluntary, as opposed to an employer requiring it, on the basis of it being voluntary, both privacy commissioners signed off on this. They've said it is part of the overall public health effort to limit the spread of COVID. They've chosen the least intrusive means to achieve that. That means the app that they've produced is based on Bluetooth as opposed to GPS. It's also leaving the data on your phone device as opposed to centralizing the data. And taking those 2 steps have really gained the support of both of the privacy commissioners. And what we know, of course, is if you've downloaded the app and unknowingly you were within the 2-meter distancing for a period of time with someone who at some point in the future, proximate to when you were near them, and that person actually tests positive, they have the ability to use the app to anonymously send out to all of those people whose respective phones were in the proximity of each other for the period of time, a note that they've been inside that distancing. We're aware of that actually occurring. And again, the whole purpose is to try to speed up the time within which people will go and get tested themselves and to supplement the manual contact tracing that's been going on by public health. So that leave this slide with simply it's voluntary. If as an employer, you're thinking of trying to make it mandatory, you've got a whole protocol you need to work through. We'd be happy to help you with it. But right now, this app that the federal government and Ontario are endorsing is voluntary. We'll leave you at that. And let's go to the next slide with some things to think about as we move into the questions. Take a look at your policies. Are they up to date? Are they specific with COVID, with respect to COVID? We got a question in the chat that obviously asked, can I terminate if somebody hasn't followed the protocols? And that will be very much based upon, did we communicate our expectations? Did we hold people accountable? Have we coached them? And have we used progressive discipline? So short answer, you could terminate somebody, but again, it's all about the protocols and the paperwork you've got in place. And really some patience around not just work refusals, but the kind of accommodation people are going to be seeking that Brian talked about around family-related issues. I think you're going to see a very big spike in those. We're happy to help any of you with that as those questions pop up. They will be very context-specific. And you can actually start to draft flowcharts and or check list to help your HR people or operations people interacting and going through those questions that are definitely coming. I think with that, we want to turn it over to try to open this up for questions and leave it at that. We'll invite Shelley and Mike back in, and we'll sit back and we'll try to answer the questions as best we can.
Perfect. Thank you. Thank you so much. That was excellent and very thorough. Mike, you can, oh, there you are. Hello.
Hello, everyone.
We have 9 minutes left, and we've had some questions come in. If anyone has other questions, please post them to the chat, direct them to all panelists. So I'm going to start with one, Mike, if you don't mind, that just came in that I think will be very quick for you to answer. You were just talking about what happens in the workplace when you have someone who has been diagnosed with COVID-19, and you spoke to them providing appropriate clearance to return into the workplace. So is a negative test, this is the question, is a negative test clearance?
I think that the answer is that you have to pass that period of time from being symptomatic and have a negative test. I believe, is it, Mike, do you know about, is it 14 days being asymptomatic or no?
Yeah, the clearance test, remember that, and this is a great way to discuss and debate this a little bit. Clearance test is likely enough, but both lawyers on this call are going to say defer to public health. What's public health telling us? Because it's going to evolve. It's just like if we were doing questions around CEWS and accounting. We're going to point at the accountants a bit to make sure the standards are there. So I actually believe the answer is yes, that the clearance is enough. But I absolutely defer to, let's check with public health in case something changes.
What I would quickly add on that is it's hard, but well, maybe it's not hard. Ignore the fact that public health, in fact, has changed its mind. We all know at one point they're saying don't bother with masks, and then they're saying definitely use masks. Ignore that. What I mean is ignore someone saying, well, they don't even know what they're doing. They're public health. They're your touchstone for a basis to make your decision.
Right.
And so that's definitely what your lawyer will tell you in terms of justifying the reasons for your protocols.
Okay. Thank you.
Interesting.
Mike, Bill?
Okay, I've got a question. It's and it's for the both of you. It's really more of a ground floor question, literally. I've had a couple of our members reach out to me and ask a few questions, and one of the questions was, and Michael, you touched on this earlier, going back to the inspection and the inspectors. Physically speaking, the question is, how far does the inspectors' reach go under a recommendation to physically move locations for work cells? So I've been through many shops, of course, my entire career, and sometimes we have people working within that 6 foot or less threshold, and just by the sheer size and magnitude of the equipment, it just can't be moved all too easily. So if the personal protective equipment isn't enough, can the inspector force an employer to move work centers or workstations?
Yeah, unfortunately, the inspectors have, from my perspective at least, they've got pretty wide span of authority with respect to making orders, as long as they're hooking it to something in the Occupational Health and Safety Act and or its regs as it applies to your workplace. But remember, sometimes what we get is an order to make a change, like you've described, Mike, but right below it, we get a stop work order. And those are the situations where they've levered their ability to issue a stop work order. But every employer in Ontario is allowed to go to the board and appeal that order and try to seek the Ontario Labor Relations Board's overturning of the order, whether that be a stop work order or an order to change a cell or to move something around. Our advice right now is you want to cooperate with the Ministry of Labor inspectors as much as possible. You want to bring your expertise and influence and advocate for what you want to see happen in this circumstance, because the short answer is they have that front end power to issue an order for sure. It's then you're stuck with making an appeal. So we spent a lot of time trying to work with them in advance to educate them as to why we think what we've done is appropriate.
Right. So it's really more proactive up front, of course, and then reactive when it comes to that point.
Yes.
Yeah. Entirely. Okay. Thank you.
Okay. I have another, I think, short answer one that just came in. So on the workplace, still on the workplace, you've got someone who has been tested positive for COVID-19. So if an employee tests positive and has been in contact with other employees, is the employer required to provide a paid quarantine period?
No, it doesn't have to be paid.
There's a short answer.
It is.
Don't beat around the bush, Brian.
It's
Okay.
easy and quick to deliver the good news, right?
Yeah, yeah, no, that's okay. So the answer, no.
Exactly.
Mike, we had one that came in advance, and it was related to, you know, when children return to school. Do you want to take that one and bring that one up to Michael and Brian?
Yeah, exactly. So the question really stems around what are the legalities that surround basically forcing return to work by the way of what the legislation requires for return to school. And I know there's there's a lot of different angles to look at this and dream up 1,000 different questions about it. But legally speaking, what are your guidelines and what are your recommendations to deal with basically that entire situation?
Yeah, so if it's all right, Mike, I'll jump in on that. Again, as I mentioned, I think it's important to keep in mind that deciding to keep your child home from school is a decision. So it's an election. Again, carve out situations where there's specific medical issues or sensitivities involved. Otherwise, you're making that decision, and so that's going to be a hard entry point for you to assert back to your employer that you have to be accommodated in that process. I mean, there's any number of examples. I think another one that I actually meant to bring up and I didn't is that group, the high school group, where the teenagers typically are going to be at school, off school, at school, off school, and you know, could a parent in that circumstance access a leave? Well, if you're in the teenage group period, there's going to be questions perhaps about why you're required to care for them. Are they not old enough to care for themselves? But otherwise, you know, you could have circumstances where that threshold is crossed, and you could even have a leave that would go on and off, on and off, on and off. So there's any number of potential fact patterns. I think it's most important to remember that if you're talking truly about an election and not caregiving needs tied to a medical issue or an at-risk issue, then you would be a right to approach it. I would use the word skeptical, but you always want to be open and approach it in good faith. But absolutely, sort of consider whether you really have to accommodate this employee or not, right? But I think in the majority of those cases, you're going to have to look at it so specifically that you might want to reach out to someone to get solid advice.
Yeah, it almost seems as though literally everything is going to come down to a case-by-case basis, right?
Well, particularly in family status and accommodation issues, more than almost any other area. That's where the specific facts matter.
Yeah, I'm sure that's not the last of it.
Thank you. So we're getting really close to 12:30. Okay, so another question just came in. So something we recently had a webinar about returning to Canada after having been in the US and how to get your employees safely and appropriately across the border. So here's a question related to that. So when an employee returns to Canada after traveling for business purposes, work-related purposes, and the public health guidance at the border is that the employee should be self-isolated for 14 days. Is the employer required to pay that employee while they're off for that 14-day period? Again, assuming they're unable to work remotely during that 14-day period. So they cannot report to work for 14 days. Does the employer pay them or not?
No, I can't answer this. It has to go to Brian, given his earlier answer.
Yeah, well, I mean, it's interesting how it ties into the earlier answer with respect to, you know, someone who's been in contact. I mean, so we have clients that their employees would go and travel. And I guess I think it has to be the case that if you're requiring the employee to go, knowing full well that they're going to be required to quarantine when they come back, it's probably enough to move it into the category where it would be right that the employee would be paid. It's an employer's choice to make that happen, I think. If the employee was off traveling on vacation and came back, that would be a different set of circumstances, right? I think that's my answer to that question.
Yeah, I agree 100%. I want that expectation though set before they even travel.
Yeah.
Right?
Yeah.
So
Makes a
in
lot of
other
sense.
words, you know, as employers, we really have to anticipate a whole lot of what if scenarios so that we have already thought through how we're going to respond to them. And we're also going to need to be flexible and nimble and prepared, which our survey showed us 80% are have plans in place to be prepared for the second wave that's being forecast for us. So thumbs up to everyone who has that. So it's 12:32. Mike, I'm going to draw it to a close. We've got more questions that have come in. I apologize that we haven't been able to get to all of them, but we are trying to be sensitive to everyone's time. So,
Yes.
Mike Bilton.
Yes. So, I mean, it's quite simple, right? Brian and Michael, thank you so much for facilitating yet again another very informative hour. And judging by the number of questions that keep piling in, there may be a part 3 that we may have to reach out to you on. So, special thanks to Automate Canada and to the Canadian Association of Mold Makers for helping facilitate this. Carly behind the scenes, our technical expertise officer, is helping out greatly in this area. Hi, Carly. So thank you once again, all, and another shout out to our community partners at Windsor Essex Economic Development Corporation, and special thanks to Nancy Creighton at NEDJCT. Thank you all again, and that's it for today. Have a good day.
Thanks for having us.
Thank you.